So I give now the floor to Professor Sandra Friedman. I thank you very much your participation. You were an inspiration for us to do the launching finally because you were here, and she will present her contribution to the book that is on women's rights. Thank you very much.
Well, thank you very much. Can you hear me? Yeah, thank you so much for having me. It is really very exciting to be here, and all in all, it's been a very exciting project to be part of, very challenging, and although I'm South African, I now live in England, so again, the comparison has always been intuitively to go north-south, although I've worked a lot in India, but for me, the opportunity to discover the Brazilian jurisprudence has been enormously illuminating, and I do feel very pleased and privileged to have been part of this project. So my contribution to the book was on an analysis of the South African Constitutional Court's jurisprudence on gender. And if you look at the book, you'll see that there is also one by Daniele Kawa about the Brazilian and by Indira J. Singh about the Indian. So we did it in parallel, although we cross-referenced each other. So my contribution is on the South African, but we can, in the discussion, try to draw out the comparative sides. Okay, so I wanted to start off by talking about the context in which the jurisprudence on gender in South Africa happens. And I call it gender at the confluence because the question of gender in South Africa is very complex. Whereas in the transition from apartheid, it was very clear that the racial issues, the issues of racial discrimination had to be dealt with. The questions of gender discrimination were much less intuitive to the political actors and to the courts, as we'll see. And I think probably the best way we can describe gender under apartheid is there's a really interesting book which I could commend you to called Maids and Madams. And I think as Brazilians you would understand this connotation very much because it's the white women who are the madams and the black women who are the maids, so that the interests and the type of discrimination experienced on a gender basis was also racialized, and that's what makes it a complex issue. So as far as the black women were concerned, within apartheid, black women were discriminated against on all levels. Obviously on the racial side, but because of apartheid, black women were either, because of the migrant labor system, the black men worked in the cities and the black women had to remain in the rural areas looking after the children. But those black women who came into the cities, predominant or 99% worked as domestic workers within white families, which also led to a particular relationship of power between women and women, that is, between the maids and the madams. But there was also another whole stream of customary law, which is perhaps foreign to Brazilians, but perhaps you have a similar system for indigenous law. But black society has always had its own legal system, which is mostly an oral law, but it is also very patriarchal, and I'll say a bit more about that. And so even the black customary law is very gendered. But that's not to say that white women did not experience discrimination, and the black women and the white women shared in common a legal system which was intensely patriarchal, particularly the family law and the marriage laws, which still saw marriage as giving men the status as the head of the household, particularly marriage in community of property, and I'll say more about this. But so the bottom line, so basically, whereas for white women, much of the imperative was to be able to get out of the home and into paid work, which has been one stream of feminism. For black women, a lot of the time it was to be able to be with their families and to look after their own children and not look after white children. And I think as a result of this, you can see this is a quote from Justice Sachs in one of the cases which I'm going to discuss, about how complex a transformational approach is to gender. And what it says is, sorry if it's at the bottom, you can see, it says, sexism and patriarchy are so ancient, all-pervasive, and incorporated into the practices of daily life as to appear socially and culturally normal and legally invisible. And therefore, the transformational enterprise was not as obvious. And that's why I think to talk about how a transformational court can address gender issues is at the cusp of how we should be analyzing both transformational constitutions and transformational courts. So what I've done in the chapter is to take all the cases about gender until the time of submission, and as we've all been saying, this was a long process, so it doesn't have the very most recent cases. But actually, as it turns out, there haven't been enough major cases to make a difference to this analysis. So I looked at, I think it was about 11 cases. Because it's a new court, we have a finite jurisprudence, not like the Brazilian court. And between the beginning of the court and the time of writing, there were about 11 or 12 cases which we could identify as being gender cases. And I analyzed them. But in the process, I needed a methodology of what you call a transformational court. And this was something we discussed in our workshops in the course of the development, as to how we decide what it is to be a transformational court. So, and then I tried to use these criteria to analyze the cases. So the first thing you could say is that a non-transformational court would just look at the case before it and make a decision on that case, whereas a transformational court might set out much more general principles which would impact on the broader structures of society. You might be critical of my framework, which we talked a lot about, but this is the framework which I used. And a similar point could be made that you could look at the text in a very formal way. You could just read the words of the text literally, or you could try and get to the background, spirit, or purpose of the Constitution. But on the other hand, there are limits as to what a court can be, and I think we've already touched a bit on this in the discussion, on what a court can do, because generally speaking, although the Indian court is somewhat of an exception to this, but generally speaking, the court is a passive institution. It has to wait for claimants to come to it. So a lot of the transformational potential really depends on the type of claim. And this comes back to Oscar's point about it depends on how civil society plan their claims, and also much more on transformational lawyers, or at least as much as the court. So for all of us who've worked in strategic litigation, you feel concerned that the wrong case might come in the wrong order, and that might scupper the jurisprudence. So there's the question of the type of claim, and there's also the question of the nature of the claimant. And you'll see, as I'll talk about the cases, that there's a concept which we've begun to develop called judicial empathy, where the court thinks of the claimant as being the kind of victim that they think their transformational halo should extend to. So quite often you hear, and I think even Zach Yaqub, who was the South African judge who was part of our deliberation, South African Constitutional Court judges will say, we want the victim, we want the poorest of the poor, we want the person who has nothing to come to the court. But that does mean in the gender situation, they may not see, and we'll see that the court may not actually see what is the gendered issue in the claimant, particularly if it's a sex worker, which is one of the cases, or if it's a cohabiting woman. They may not actually see it as the kind of claimant they want their benevolence to extend to. Then, of course, there's something which we've again begun to talk about, which I call comity, which is the relationship of the legislature to the judiciary and to the executive. And of course, we all know from the experience of the US Supreme Court and others that the vocal minorities may not be transformational. They may be very conservative. And it may be that the government is transformational and the court is being prayed in aid to obstruct liberal or progressive policies on the part of the government. And I think the South African Constitutional Court has been very aware that we are a new democracy, that it's the first time that people can vote for the kind of programs they want, and that the court should be going along with the parliamentary democracy. So in a way, transformationalism might be deferent. It might be that a court has to not interfere. And in my sense of the South African Constitutional Court has it's been quite concerned that it should leave progressive decision-making to the political processes. And then, of course, there's the nature of the evidence, which I'll talk more about, and the nature of the remedies. So in the end, I think the challenge is one of intervention versus deference around gender, and this has proved to be very complex. So these were my criteria for analyzing the cases, to look at whether there's been a substantive or a formal interpretation of the text, to look at the court, were the women judges coming to different decisions to the men on the court, and were the black women coming to different decisions? How did the court respond to the particular claim before it? Was it, again, narrow or broad? How did it respond to the nature of the claimant? And this is the point about judicial empathy. What is the question of comity? And also, I thought there was an interesting point about how the claim was framed, because our constitution, the South African Constitution, has socioeconomic rights, as does the Brazilian. And a lot of the cases on socioeconomic rights have actually been brought by women. So those of you who are familiar with the South African jurisprudence on right to housing, right to health, the main South African housing case, Grootboom, was brought by a woman. The main case on health, the one that made a difference, was about pregnant women and HIV/AIDS, but they didn't see these as gender issues. They saw these as poverty issues. So I think it's been interesting that the framing of the gender cases has only been when it's been seen as a specifically, one might say, gendered issue, whereas actually you could read the housing cases as gendered cases. You could read them along those lines. Okay, so to look at the cases, the first branch of cases were on family and these are the main topics that the cases have been: family, marriage and cohabitation, customary law, violence, father's rights, and sex work. And those were the cases which, that's my broad classification of the cases. And I then grouped the cases into the ones in which the courts were transformational in the sense of taking the lead, and then ones in which the courts were, from what I regard as a gendered perspective, regressive and not transformational. And that's quite nice because it frames it similarly to the way Aravind looked at the Naz decision in the Delhi High Court and the Supreme Court. So the way in which the courts were in the lead were mostly on straightforwardly patriarchal laws about marriage and family property. One of the first ones was called Brunk, and it's about marriage and community of property. I don't know if you have this in Brazil, but community of property basically means there's only one property holder after marriage, and that's the man. And then that means that the whole woman's personality dissolves into the household. This is it's actually an English common law of coverture coming from the 19th century. You can opt out of it, you could, but it was only reformed in about the mid-1980s in South Africa. And this had an effect on survivors' benefits. So it was quite an arcane particular issue, a very narrow particular issue, but the court was able to see it in a much broader sense. So in that sense, it fulfilled the first criterion of taking what looked like a really quite abstruse idea of who can inherit the benefits of an insurance policy to a much broader attack on patriarchy in family and marriage property law. The Van der Merwe case was about a terrible case of gender-based violence where the husband actually ran over his wife in the car. And so it was a gender-based violence case, but it actually came to the court because the community of property meant that she couldn't sue her husband in negligence because of this idea of a single personality. So that had an effect on her claim against the insurance company for basically under the motor car vehicle insurance. So again, a fairly, what looks like a narrow technical issue could be broadened out by a transformational court into a much bigger attack on these patriarchal laws. And the same was the Gumede case. So those three cases, the court was able to, and these are the words of Justice O'Regan, one of the white women on the court, who's been a foremost spokesperson of the court. She described this as boundless patriarchy, where the husband wielded marital power of the wife and children. The estate was deemed to be one, indivisible, and subject to one command. And that was something the court found very easy to strike down. So if we evaluate this on the criteria that I used, you can see that they went beyond the specific claim to much more structural change. So this is a quote from Justice Moseneke, where he says, "There's no doubt that in our society, domestic violence and economic vulnerability are gendered in nature. Both are a sad sequel to patriarchy." So the court was able to grasp some of the very deep aspects of patriarchy as we know them. But interestingly, as far as the comity is concerned, the distinction between the distinction between the legislative and the executive wasn't great. So this was perhaps an example of the court taking on a legislative role because the legislature hadn't got round to it. But there was actually no resistance. So the government was not actually defending these cases. It was a paralysis, perhaps, a situation in which the legislature had never got round to reforming these laws, and they left it to the civil activists in the courts. But the other case of Bear was, again, a transformational case. So that's meant to be a picture. I couldn't find a good picture because all of the pictures were copyrighted. So our free book is very good. I couldn't find a really nice picture of the informal settlements in South Africa. But you'll recognize what an informal settlement or a shanty town looks like. And she was a very poor black woman. And this was one of the few cases which has actually been brought on to address poverty, but not framed as a poverty case. So all their belongings were materials to build their own shack, a small piece of land. But because she was governed by customary law, when her husband died, there is a rule of primogeniture, which means that the inheritance all goes down the male line. So she could not inherit any of his property, meager as it was. It went to his father. So his father inherited the property, and the sad part of the story is that it was so little that the father wanted to use it to pay for the funeral of his son, but that would have made her homeless. So this was the possibility of using this case to challenge the whole rule of the customary law of primogeniture. And again, it was a tricky case for the legislature to address because the South Africa constitution makers were very keen not to replicate colonialism in relation to customary law. So there is a strong sense of wanting to value customary law as equal to colonial law. But then there were these gendered aspects of customary law. So the legislature didn't really want to and was dragging its heels about getting rid of customary law of primogeniture. And this is why the case came, and there was the court was able to make a substantive interpretation saying that it violated women's dignity because it implied that she was not fit to own property and left her as a perpetual minority. So it really struck at one of the most important intersectional issues for black women. It doesn't affect white women because they're not under customary law. And this meant that they were able to actually override in all respects, and this is probably the highlight of the gender cases. Okay, so in all of these, we can say that there were changes in family law, it was interventionist and appropriate, but as far as it's concerned, we can take what was money from the state. So as far as the resources issue was concerned, the court wasn't actually asking the government to spend any more money, and that made it easier for the court to be more interventionist. Okay, now judicial retrenchment, and more recently there have been very conservative decisions by the court. And I've grouped this under ideological, which is much more of a focus on a very liberal idea of choice. And when you asked about values, the question of autonomy as against dignity has come up very clearly. A narrow interpretation, a very deferent approach. And one of the reasons for this, I think, has been this point about judicial empathy, because the kind of claimant that came before the court was not one that the court identified as the transformational beneficiary. So the one was a civil partner, the one was a male prisoner, and the other was a sex worker. So not the kind of claimants that the court identified with. So this is the case about Fawkes, about cohabitation. And really the question was whether a couple who lived together without marrying, she could inherit his, she could have any claim over his estate as she would have been if she were married. Now, the law on cohabitation in South Africa hasn't crystallized as it has in Brazil. But the court, but actually because of the whole migrant labor system, there are very large numbers of women living with men in a cohabiting relationship, and the result of having no marriage is that the woman has no rights at all against the man, but is often in practice in a situation of great vulnerability. So to understand this, you really needed a court to grasp a complicated social context, which the majority did not, because they were much more interested in the question of choice. The man's choice not to marry, which they presented as the couple's choice not to marry, and the testator's choice not to leave money to the cohabitee. So unfortunately, this case was lost, but you can see alternatives to how one might have had a much more substantive interpretation. This is a Canadian judgment by L'Heureux-Dubé, who some of you might be familiar with. It's small consolation to be denied protection by the virtue of the fact that one's partner had a choice. And this was the dissent, 2 women judges who were in the dissent. So we can look again at the composition of the court, where they said you should really treat relationships functionally similar to marriage as if they were married. But the majority were very keen that this is something to be left to the legislature and not something for the court. The second area where it has retrenched is on reinforcing stereotypes, and this was the prisoner case. This was a case quite soon after the beginning of the new democracy, where Mandela gave an amnesty to all women prisoners who were the carers of minor children. The case was actually brought by a father saying that he should also be able to come out of prison because he was the carer of his minor children. And so you can see it was a very complex case for a court to navigate, because it looked like a very progressive decision. It was in favor of women. It was letting a lot of women out of prison. It was the president, magnanimity. He was pardoning them. And then here along comes this male prisoner, and the court isn't very engaged with him. So in the end, the court said, well, this is a good thing. The president has done a good thing, and we can't possibly allow all these men prisoners out of prison. And so they turned down the case. But really, in the end, were they perpetuating the gender stereotype that it's the women who look after the children and not the men? And there's an interesting dissent, interestingly, by an Afrikaner male judge who says that actually this is bad for women in general because it reinforces their role as primary carers, and bad for men because it doesn't give them a place in caring. But in the end, the court was very deferent. It didn't take any real evidence about gender stereotyping. It simply said, this is the president's good will towards women prisoners, and we should accept that. So that puts the women on the pedestal as the child carer. And then the last, most difficult case was the one about sex workers, where the case was brought by the sex worker or the prostitute on the grounds that criminalization, so in the South African law, the women prostitutes are criminalized, but the male clients are not. And they claimed that this was discriminatory. And this was a case where, a bit like the Naz case, was very disappointing to activists because they'd built the case very carefully around a social movement. They'd brought it to the court with a lot of evidence about sex work, but the court was not having any of it. What it says was, this is not a gender discriminatory provision because the criminalization simply says any person who engages in sex for reward. And any person could be a man or a woman. So this is the most formal approach you can get to equality because in reality, all the people who are ever prosecuted are women. The vast majority of prostitutes are women. And the court refused to see this. This is Mhobo, who is again, a black. If you want to identify, if you think identity of judges made any difference, he's one of the black judges on the court. And the fact, he also made a lot of the fact that the men could be prosecuted as accomplices in the crime, but wasn't interested in the fact that they actually never are. And you can see the substantive alternative here, which was, again, both the women on the court and one man dissented. And they said they could see beyond the image of the prostitute before the court. And they tried to address this question of judicial empathy by characterizing the prostitute in this way, but this was not accepted. So we can see the female prostitute has been the social outcast, the male patron accepted or ignored. She is visible and denounced. He is faceless, who returns to respectability after the encounter. The inference is that the primary cause of the problem is not the man who creates the demand, but the woman who responds to it. She is fallen. He is at best virile, at worst weak. So the court was not prepared to accept this view, and they were much more deferent. But interestingly, even the dissent was deferent and said, we will say this is wrong, but in the end, the result should be left to the legislature. And again, it's a very small it's a very small minority, and it's not very easy for this minority to have any impact on the legislature. So the way forward from formal to substance, and one of the things which we could talk about is what is the role of a court in transformation, so that it doesn't actually obstruct progress, but it keeps working towards progress. And one of the important things is that it insists on proper, well-justified, well-grounded government explanation. And we can talk more about this, but I'm sorry if I talk too long.
Thank you very much for the presentation and the effort to create the categories. I was thinking all the time, if it's so difficult to make categories within one court, imagine when you try to compare three. Yeah. But it's a good effort, because many of the things you mentioned, I think for us, especially when we try to think cases we want to take to the Supreme Court, were very important. I think the idea of the nature of the claimant is one I've been thinking a lot, and there's a bad decision of the Brazilian Supreme Court on the amnesty law from the dictatorship that has no claimant. It's an abstract case. And I think it has a very strong effect if you have a person, a family, somebody, I won't say crying, but somebody before the judges when you're taking those decisions that in political terms are making some crisis within the system. So I will open for questions now. Ok, tenho Marta e depois nosso colega. Eu não sei onde está o microfone. E aqui.
Hi. I think the customary law is established in the South Africa Constitution. I don't know how the judges solve this conflict. And I would like to ask you if the African Commission Human Rights, if it already addressed this customary law issue and the gender issue, and if what the African Commission says affects or not the South African court. Thank you.
Marta, thank you.
Hi. I was also enjoying a lot the criteria and started to think about every decision. I was studying this last year, and I was wanting to do two comments. First is that it's very interesting to look closely to the interpretation and the argumentation of the decision, and that puts for us, I don't know how it works in the South African court, but our constitutionalism or our decisions of our constitutional court, they have a very strange aspect in terms of a collective decision, because what we have is like a collective output, but we have different decisions for different judges. So they all have the difficult cases, they have individual decisions with different argumentations, and they can all agree in the output, but they can have many different they frame the case very differently, and they might even disagree about some points about some important issues that some of them decide that think that are important to come to the same decision. So it makes our work a lot more difficult to come to a conclusion of a court, of what's the institutional meaning of the decision, because we have 11 different meanings many times. And another comment is also, it's very interesting to separate the output and the interpretation to come to this idea of transformative. I was thinking about a very important decision on domestic violence case. We have in 2006, we have a new statute on domestic violence, and it has been for more than 6 years put in question because many judges were saying it was unconstitutional for different reasons. So it was like an important movement from the executive to put the case, to send the case to the Supreme Court to finally get a statement that the law is constitutional. And that was also very important for the social movement. But when we look closely to the decision, okay, finally they said the law is constitutional. But if you look closely to the arguments, if you go to your criteria of judicial empathy, the woman in this decision is always seen as a victim, as unprotected, as some that need protections from state, and they are not seen as autonomy to decide about how to deal with the case. So the state has to protect them. So the empathy was towards a very weak image of women. And as also when you see how some judges frame the case, most of them frame the case as a protection. The law is important to protect the family and not protect the woman. And it was not gender violence. It was a violence that was destroying the family, and they recognized the substantial argument that, okay, in the social situation, the women are the ones that effectively suffer the violence, but that's a problem for the family and not a gender problem. So I think your criteria was really very interesting to analyze the decisions.
Thank you. There's somebody there? Você falou, cara? Não. Então não. Não tem outra pergunta. Okay. I have a question, but I never know how to do it. What about the discussion on polygamy and the women's movement. I might say, for me, it's very shocking that the president has several wives. I don't understand it, but I don't know if it's how it's seen by the women's movement in South Africa, if it is a problem from a gender perspective or not, and if there's a discussion. Okay.
Well, those are also really difficult questions. So on the question of customary law, I'm not aware entirely of what the African Commission has said about customary law, but I can tell you about the South African debate, which didn't really, it didn't see the African Commission's contribution as central as the domestic debates. But the customary law is oral law, which is administered by the traditional leaders. And the traditional leaders are actually quite powerful in the South African political system, in the sense that around the time of transition, it was important for the traditional leaders to be incorporated in. And there was also a sense, as I said, that the value of customary law was an anti-colonial value, and that if there was going to be equality, there was going to be much more of an African focus and much less of a European focus. We needed to have customary law in the Constitution. But because customary law has got these patriarchal issues, a decision had to be made as to which took priority. And the Constitution is very clear that equality is more important, gender equality is more important than customary law. So there is a very clear mandate in the Constitution for the courts to have said that where customary law conflicts with the overriding right to equality in Section 9, then the equality right takes precedence. So that's why the Bear case was an important case, because there'd been a lot of attempts within the legislature to get rid of the law of primogeniture, which is male succession. But because of the political strength of the traditional leaders, it couldn't happen in Parliament. And that's why it had to happen in the court. And in a sense, that was what on all the criteria, why I say that's probably the most transformatory decision in the gender field that we've had. So I can't comment exactly on the Brazilian, the way in which you have all the judgments, but I can see it must be extremely confusing. Obviously, the other end of the spectrum is the civil law approach, which is you just have one judgment, like in the French court, and the European Court of Justice does that, which is it's just very, very cryptic, much too brief, and you can't really do anything with that either. So you wouldn't want to go all the way to the other extreme. But if you can get them organized into collective, a majority decision and a dissent, it's useful for future analysis, because as we know, a dissent can then be the focus of future activism and can then become eventually the majority if the social activists are properly organized and convince the majority. So the reason I put in the alternative dissenting opinions is because it's useful, firstly, to see how else it could have been organized, and secondly, to see what might be the focus. As far as the institutional side, though, of how the court makes a decision, the South African court, from the very start, tried to be very collegiate in the sense of collaborating. So they will try and have a unanimous decision wherever possible, which means that one judge has responsibility for writing the judgment of the court. And it's quite open about this process. And then the judges will circulate the judgment, and they will have their discussion internally about how they want the judgment to come out. And if at all possible, they will come up with maybe the maximal compromise, but probably not, probably somewhere, some kind of compromise, that it will be, if possible, the whole court. But where not possible, they will then have dissenting opinions. But generally speaking, so there have been a lot of dissenting opinions on these very contested cases, which are not going to get total unanimity. But there is a strong sense that there should be a single decision of the court. And the judges on the court are quite open that if they have to dissent, it's almost it's almost a letdown. They really want to be part of the majority. Your point about the victim, about the domestic violence and how you characterize the case is very, very important. And this whole idea of seeing either the problem of gender-based violence as being a family problem or seeing the woman as a victim, I think has a lot to say about the sex worker case, because the court didn't want to see women who are assertive, who are coming to assert their rights, as, I think, as the beneficiaries of the Constitution. They wanted to see the victim, but they didn't see the victim. And even the dissent of the court tried to re-characterize the claimant as a victim in order to say this is why we should give them rights. But actually, from a feminist perspective, we actually would like the strong, assertive woman who says, I'm a sex worker, I should be entitled to have my profession. If that's what I do, that's what I do. And I shouldn't have to be criminalized. But neither the majority nor the dissent, the majority just saw this as a question of morality and not for the court. And the minority tried to characterize it again as a victim in order to see it. But there was some very, if you're interested in that case, in the sex worker case, you should look at the amici, because there were lots of civil societies that put briefs in, which unfortunately the court paid much too little attention to. But all the sex work is probably one of the most complex debates that you would want to put before a court in any event. Polygamy, well, this relates to the customary law point. So I think, personally, I think it's a great shame that polygamy is permitted. So it is permitted, it's legitimate. But I think it was a strategic decision from the feminist perspective, because the idea, the sense was it would happen anyway. And the important thing about recognizing it is then you give proper rights to the second and the third and the fourth wives, or the first wife even. So once you recognize it, you can then regulate it. If you don't recognize it, it will happen anyway. And we saw with the cohabiting decisions that actually if you don't recognize these kind of relationships, the women end up being very vulnerable. So it's not really, if a man enters into 3 or 4 marriages, it's usually not necessarily the choice of the woman or even known to the woman. There might be an urban wife and a rural wife, and they may not even know about each other. Then what happens? The man dies, and what happens to the estate? If it's unlawful, then the one wife is negated. So there was a sense in which this should happen. And there's a very interesting decision, if you're interested in that, because it's such a complex society in that there are Muslim polygamous marriages, there are customary polygamous marriages. And there was actually a case brought by a woman I think it was a Muslim polygamous marriage, saying she didn't have equal rights with a woman in a customary law polygamous marriage because the Muslim one was less advantageous to the women. So I feel, in a sense, quite humble about it, because it's a really complex social problem. And probably the decision, you wouldn't want there to be polygamy, but possibly the decision to regulate it was better than the decision to let it just happen and therefore drive it underground. About the selection of the judges and why the court was positioned as it was. Well, if you look at the history of South African judiciary, even under apartheid, there were a lot of judges who supported apartheid, but there were also judges who found spaces within the apartheid legal regime for resistance. There's a very interesting, which has just come out by Edwin Cameron, who's a justice on the current court. It's also a close friend. It's called Justice. It's by Edwin Cameron. And for anyone who's interested in the South African Constitutional Court and why it's developed in the way it has, I would recommend it. It's somewhere between memoirs and legal analysis, so it's very easy to read. But so there was a strong tradition actually of activist lawyers even under apartheid, and law was still seen both as being repressive and as having possibilities for transformation. So there was already that culture. But you can read in the book, Tienes Rue, and you can read in the book, there's a lot of contestation about whether, I think someone mentioned earlier, the court is transformational or just carrying on the liberal tradition. And Tienes Rue's chapter in our book takes the view that it is not really a transformational court, but a liberal court. On the other hand, the first round of judges in the court were all really quite, had been activists. A lot of them had been activists in bringing about the change, and they were very committed to the new values of the Constitution. So in that sense, the court was particularly constructed to be the vehicle for the transformational Constitution. Now, we still have to do the analysis on the second generation court, which I think is very different, much more conservative, much more black letter, much less adventurous, although there are one or two, Edwin Cameron being one, who are still along those lines. So what would be really interesting is for someone to do the analysis of the court, the new round of judges in the last, say, 4 years, 3 or 4 years, since the first lot all retired. They all retired much at the same time, and now the court is a very different sort of court, but that hasn't been done yet.
Yes, my name is Oliver. I'm from New Zealand, here on exchange. Related to the point about judicial selection, what is the flavour of modern legal education in South Africa? Because as you mentioned, like in cases like the Volks decision, it seems like some of the jurists are paralysed by commitment to perhaps the principles of John Stuart Mill as opposed to the real harm caused by a certain application of law. So you say the second generation of courts are more conservative. Do you have any prediction about the third generation of judges coming through?
Your students.
Well, that's very interesting because the civil law in South Africa is Roman Dutch law, which is quite, we call it black letter, which is quite formal law. But so I think there are two streams, and it could go in either direction in terms of legal education. So that there is still a very black letter conservative stream, like in universities like University of Cape Town. And then there's also the fact that all of the law schools have a clinical side, and there's still a very strongly developed sense that lawyers should engage in strategic litigation. So the universities will have units, even Stellenbosch University, University of Cape Town, Wits University have public interest law units where the students work, and they'll also have outreach where they'll do clinics in the poorer areas and so on. So you hope that being involved and exposed to law as a social force or law as a social obstacle, perhaps, at least some of the lawyers will come out of these degrees with that kind of perspective on the law. But as you know, there's so many law students and they can go in all sorts of directions. But the other side is that because under apartheid, the universities were segregated and the black universities were very poorly resourced and the standards were not great, the new generation of law students is much more mixed, and there are many more black students. There's a lot of affirmative action. There's a lot of attempt to incorporate disadvantaged students into the law. And that has its own implications. Some people who come from disadvantaged backgrounds quite rightly want to go into professions where they can do well and become affluent. And so many lawyers, as in all law schools, will go into commercial law, and not that many will go into what we call social law. But hopefully there are enough out there. I think the problem isn't so much legal education as the selection process, which Oscar pointed out to, because unfortunately it's become much more political than was expected. It was meant to be a very transparent process and a very participative process through the Judicial Service Commission, which does the JSC, which does the selection. But because there's quite, as it turned out, the number of politicians on the selecting committee is high, and now that the ANC has a very strong majority in Parliament, they also have a party line on who should be judges. So the influence of politics is much greater than it should be, and one of the big influences on racial advancement, which means that people who are in any sense outspoken in terms of the progressive agenda will not actually get appointed to be judges. That's perhaps a blunt statement, but if you look at the recent round of judicial appointments, they tend to leave out dissident voices, and there are very, very few women. The number of women being appointed under the system is just miserably low. So, which I realize I didn't answer your question about judicial identity, and I didn't give an answer for a good reason, that I think it's still open for a lot of discussion as to what the judge's own identity brings to the court. Actually, one of my doctoral students is doing her doctorate on women on courts and to what extent that makes a difference to the outcome. Certainly in South Africa, there has been an attempt to have a very diverse judiciary, a conscious attempt. And now there are more black judges on the court than whites, but more male black judges, few women. And in a way, the affirmative action attempt to have an identity politics on the court, I think is showing itself as being problematic, because people are selected for their identity rather than the quality of their legal reasoning. And so I think that's become something which all of us who are thinking about composition of courts in terms of the range of experience that people bring need to be careful that it doesn't turn into pure identity politics and nothing about the quality of the judge.
Thank you very much, Sandra. Thank you very much.